welcome to the first ever California Lawyers for the Arts live stream Q&A session. We are streaming from the Youth Impact Hub here in Oakland, California. Now today we're going to be answering questions from the live audience. We're going to be answering questions that were sent in a little bit earlier before the stream, and we'll be answering questions from people online. So go ahead and type in your questions. All right. So now we are very lucky to have with us Mr. Mark Pearson. Mark here is the founding member of the ARC Law Group, which is a law group that is dedicated to business, entertainment, sports, and the arts. Did I get that right?
That's right, yeah. That's
okay.
It.
All right. So let's give a quick round of applause for Mark.
Thank you.
Thanks, guys.
Thank you.
Okay, so to get things started, Mark,
right.
could you please give us a little background on what you do and the
Okay.
types of legal issues that you see, and then we'll just launch into taking questions.
All right, sounds good.
Right.
Yeah, so thanks, Matt. Appreciate it. I'm glad to be here. I've done stuff for California Lawyers for the Arts now for like over 10 years. Great organization, and thanks everybody for coming out. Hopefully we'll be able to answer some of your questions. A little background on me. I spent 10 years before becoming a lawyer as a television journalist, mostly covering sports. I actually spent 2 years in Anchorage, Alaska, covering the Iditarod sled dog race of all things. So my background is in television, and so when I was in school, my natural transition was to do entertainment and art law. And so my practice is primarily focused on that since I graduated and took the bar. So whenever that was, December of 2005, I think is when I was sworn in. So my practice, ARC Law Group, we've been around for about 8-9 years now. Yeah, 8 or 9 years, and our focus is on working with creative, talented, and entrepreneurial clients, which I think fits right into what we're going to be discussing today. When we talk about creative, we're talking about intellectual property rights, copyrights, and trademarks. When we talk about talented, we're talking about people that are working in the arts or in entertainment. I work with a lot of musicians and actors and filmmakers and people of that do pure entertainment type services. And then on the entrepreneurial end, it's a lot of technology and people that are starting businesses. And so we look at issues of forming a business entity or setting up a partnership and whether or not that is going to work for whatever the business is that we're counseling. And the business could be a band, or it could be brick or mortar stores. So, I work with some apparel companies that have stores. So there's all kinds of types of businesses that we can work with and that are going to have different types of needs. I really enjoy what I do a lot. I tell people all the time that, when you think of a lawyer, you think of, the courtroom and all that, and the drama and all that. In the years that I've been practicing, I have been in court 3 times, twice by phone. So I don't do a lot of courtroom work. Most of my business is counseling people and talking with people. Sometimes I end up being more of a therapist than a lawyer to some of my clients. It does happen. If anybody saw me a minute ago talking outside with one of my clients, I was more of a therapist in that role because they were having a freak out over disagreement with one of their vendors. So it happens, but it's a fun part of the job. I love what I do. I like to travel around and see bands that I work with play live and keep it loose. And so that's a little bit about my background. And again, if you guys have any questions about me, feel free to ask those as well as any legal questions that you have or have submitted already. So
okay,
yeah.
All right. So if any of you are ready, go ahead and put your hand up so I can call on you and answer your questions. Otherwise, I'm going to launch into the questions that people sent in earlier.
Don't be shy.
Don't be shy. If anyone's ready right now, go ahead and put your hand up. Yes, we have a question. Go ahead. I'll probably repeat it into the mic
Yes.
so everyone can hear it.
My name is Alexis, and one of my questions was when it comes to contracts.
Okay.
I run my own business, so I'm trying to figure out if you have any idea how to draw my own contract up.
Oh, okay.
Okay.
Sure.
Let me repeat it to the microphone. Okay, so the question there was, we've got a young lady with her own business, and so she's talking about when she's drawing up her own contracts, is there a best way to go about that?
Yeah, so the first thing you've done is you've already completed step 1, and that is understanding that anytime you work with anybody in your business, you should have a written agreement. Handshake agreements can be enforceable, but in general, don't want to operate your business on a handshake. So the fact that you're thinking about having a written agreement is already way ahead of the game, and I commend you on that. Depending upon the type of business that you're in, is going to really dictate the type of agreement that you're going to need. Okay? From my perspective as a lawyer, depending on the clients that I work with, my first inclination is to look at the rights that are being exchanged within an agreement and what you're going to be doing for someone in exchange for what they're going to be doing for you. The exchange could be a monetary exchange, the exchange could be a services exchange, the exchange could be a goods exchange. But that's where I focus. When it comes to, oftentimes in my practice, especially when I'm working with people that are in the entertainment industry, I'll rely on their manager, their agent, to negotiate the financial terms. And then my focus is going to be on negotiating the contractual terms that have to do with rights and the contractual terms that have to do with how things work. So it really kind of depends on the business, but in general, you're in the right direction because you're thinking about having a written agreement. There's a lot of resources if you're putting something together that's fairly simple. And oftentimes, I will have people that come to me and say, I've already started to putting something together. I want to hire an independent contractor, or I want to bring someone on as an intern or something like that. And I've already started the process of putting together an agreement. Can you take a look at it and see if it looks okay or add anything that might be germane? And sometimes that's more cost effective. I think it is probably important for anyone who's drafting an agreement where they're working with someone or another business, and they want to make sure that the agreement really protects them, to have it reviewed by somebody. I know that in a real world context, it can often be cost prohibitive to hire a lawyer, but in general, you can find attorneys that are going to work within your budget, and it probably is a very good idea to at least sit down and have somebody take a look at something and maybe offer some comments, even if they're not going to draft it for you. Hopefully that kind of answers your question there. It's kind of tough in this context because I don't know exactly what your business is, and so I don't know exactly what your needs are. And quite honestly, in a forum like this, I don't necessarily want you to give me specifics because we don't want to waive your attorney-client privilege, and we don't want you, giving away information about your business that you might not want to. So we try to keep it kind of general in these forums. But if you wanted to talk specifically later, Matt or Bob, contact CLA, and they'll hook you up with somebody, and they'll be able to answer your basic questions for you. And that's a really good resource. CLA is a great resource for issues like that because you can get, for very low cost, some consultation and some answers to some questions that you might have.
Yeah. Did you have a follow-up question to that?
I was gonna say, like, starting from the bottom up, like, if you try to start a business and you wanna progress, but you don't have no money,
Right.
To hire these people,
Yeah.
how would you draw a contract knowing that you provide, like, recording services or
Yep.
whatever the case is?
Okay, hang on. So that question was, when you got limited funds and you're starting a business, what's the best way to go about it?
Yeah, and like I was just mentioning, CLA is a great resource for that because you can get a consultation with somebody who's going to be able to answer some of your basic questions, maybe even take a look at something that you might have started to put together, and kind of help you walk through those issues. And Matt, you can probably answer this better than I can, but the resource with CLA, it's pretty inexpensive to get a consultation with a lawyer, right? I don't know what the fee is, right?
Yeah, so when it comes to people who have a limited budget, we do encourage you to call us because we do have resources and attorneys available who can take those sorts of cases either pro bono, free, or for much, much lower cost. So there is an admin fee to get started. If you're a member of California Lawyers for the Arts, it's $20. If you're not a member, it's $35. And then, yes, I see another hand go up.
Yeah.
I just wanted you to maybe talk a little bit about the screening process for folks that might want to get pro bono services.
Okay, so that question was, they wanted us to talk about the screening process for folks who want to get pro bono services. Now, I just want to be clear, this is not going to be a huge plug for CLA. That's
Right? It
not
kinda
the
went that
entire,
way,
yeah,
right?
not the
And
entire
that's
purpose
great,
of this,
because CLA is great, yes.
Q&A, but we'll move on. Okay, so when it comes to the screening process, we do have to be careful. So we are going to ask people who want to go through that to fill out a big financial screening form, and we will need to see some tax information from you. And if you have questions about this or want to know more about it, please talk to me after the stream, and I can go through that about what's expected. Okay, all right. Okay, yes.
Okay, I have a question concerning your rights, about your product. If you have
Okay.
like a secret recipe,
Okay?
and you know you want to put the ingredients because people need to know what's in your product because they may be allergic to it.
Okay?
However, how does it work if you don't want someone to mimic your product?
Okay, all right, so that question was, if you have a product and it's a secret recipe, but you want to put the calorie information or all the other ingredients on it so people can be sure about their allergies, how do you go about that without giving everything away?
Yeah, so that's a tough one, right? I mean, there are certain companies who will give away their ingredients, but not the formula behind it. Like Coke, you can look what the Coke ingredients are, but no one can replicate the way the formula is actually put together. So that's kind of, one of the keys. To some extent, you may have some copyright protection in the way that the particular packaging is put together. You're going to have trademark and brand protection in the way that you position the particular product under a trade name or brand name. So you're going to have that there. But once you kind of disclose the information, you're right, it's kind of out there. So what it becomes oftentimes is it becomes, well, I always tell people Google wasn't the first search engine on the internet. It's just the best. Why? Because it positioned themselves the best. So if you have a formula with something, you take it to market first, you make it the best possible product and market and promote it the best so that everybody wants your version of it. That way, if knockoffs come around and you don't necessarily have the intellectual property protection, patent, a copyright or trademark that you can enforce because of some aspect of what you needed to disclose in the recipe or whatever, that people still will buy your product as opposed to anyone else's because yours is better. I mean, there's an Oreo cookie and there's a Hydrox cookie, and they are essentially the same, but nobody buys the Hydrox because it tastes just a little different than the Oreo. You know what I mean? So that's a big key component to it. Is not necessarily a legal issue, but making what you do better than everybody else's is oftentimes, one of the key ways to protect what you're doing. If you don't necessarily have protection under intellectual property rights laws because of the nature of what you've had to disclose.
Okay.
Yeah, does that make sense?
Makes sense.
Sure.
Okay.
Thank you.
Yeah, for sure.
All right, we got another question. Go ahead.
So we're actually working on the game company. So my question is, what are some steps to creating policies and procedures for development?
Okay. We're
Okay.
talking video game? Oh, sorry, go ahead.
Okay,
Sorry.
so
that's
to repeat that, in case it didn't get picked up, we've got some guys making a video game, and so they're curious about policies and procedures to put in place. Okay,
Okay, so policies and procedures in terms of like the people that are working on the game,
Yes, in terms of development, some artists need some help or guidance.
right?
We create steps so it's like he knows for this, not to go to for that, other things he should do, resources he should look up.
Okay. You wanna answer that, or you wanna repeat the question?
oh, I'm sorry. Okay, so we wanted to know, it was basically a communication thing. If we have one person who's doing, you said the pixel art, and we want them to be able to communicate with someone else who's working on some other asset, what's the best way to go about that? Kind of how to put that in place?
Yeah.
All right.
Okay, so from a business standpoint, there's a lot of different ways you can do it, and it's really gonna depend on how big your organization is. But let me address the legal issue that's kind of behind that, and that is that you're gonna be developing something that you may not have already created, and so may not be covered under a copyright, not even a lot of brand name behind it. You may be in early stages, and don't even have trademark rights established. So it's really important for the people that are sit down and work on create this new game or games that you guys are coming up with to have a written agreement amongst yourselves that says minimum what you work on together is going to be owned by your collective. So if you could set yourselves up like just a general partnership and you guys will agree that the partnership is going to own the fruits of all your labor, or you could go down the road of forming a formal business entity and setting up an LLC or corporation and saying that the LLC or the corporation is going to own everything that you work on. Then to the extent that you work with anybody outside of your business. So you bring someone in because maybe you want someone to come in and show you how to work some new animation technology or something that's associated with the game. You're going to make sure that you have them sign a non-disclosure agreement, a document that says that anything that they learn about your business they cannot use except in furtherance of helping you with your business, and that they can't take it and use it for themselves or do anything else with your ideas and concepts. Otherwise, they'd be breaching the non-disclosure agreement, or you'd have the right to seek restitution against them, sue them, or get an injunction against using your ideas. That's the best way to protect yourself early on when you may not have copyrights, patents, and trademarks in place yet because you're early. But you have a great idea that maybe it's not copyright protectable, but you have something that you want to be able to start talking to other people about. So again, I think it's really important for a new company such as yourself, one, to have that internal agreement that says what everybody that works on this project, what their rights are and what the rights are of the collective group. And then second is to make sure you have an agreement that you're going to use with anybody that you consult with that's outside of that group, saying that what they learn without your permission, that they're using it to help you and that for no other reason. Does that make sense? Does that help a little bit?
Did that clear it up, or is there anything else left? Okay, all right, great, fantastic. Okay, at this point, I think it's a good time to maybe take some of our questions that were submitted a little earlier.
Right on.
Before the stream began. Okay, so this next one is a little long. What needs to be included in doing contracts with fellow artists and producers for my music?
Sure.
What needs to be included with painters and graphic designers when contracting for commissioning and licensing their work? What needs to be included in contract with models to use their image on a worldwide basis in all mediums when they participate in music or video shoots with my company? It's a big one.
Yeah, so the bottom line again is a written agreement. That's what's needed. Now, what's in the written agreement is going to be different for all those scenarios. By example, if there are two people that are writing music together, they're going to be creating a copyright. Specifically, they're going to be creating a copyright in a composition and perhaps in a sound recording that they record. But as writers of music, they're going to be creating compositions. There's going to be a copyright there. They're going to need to address who owns the copyright and what interest that they have economically in the exploitation of that copyright. So that's what's going to be important on that one. What was the next one?
All right, so the next one was, what needs to be included with painters and graphic designers, specifically then when contracting for commissioning and licensing their work?
Yeah, so, okay, so if you're an artist and you create a work and you're selling that work itself, but you're not selling the underlying copyright necessarily. So you as the artist retain the right to make prints of your work or to license your work for inclusion in a video or something like that. But what you're selling is the actual lithograph or maybe it's even the original work itself. That's what you're selling, but you're not necessarily selling the underlying copyright rights. Sometimes you are. So it's very important when you have an agreement, and like if you work with a gallery or something, that it's clear when you make that sale what rights the person who's obtaining the artwork is receiving. And oftentimes it's just the right to have the artwork. You may also, as an artist, want to preserve your moral rights, which are not inherent in the United States. Moral rights meaning you can stop someone from wrecking your work. Right now, if you're an artist and you sell something to someone in the United States, and they buy it and it's your prize piece of artwork, they have the rights to walk home and throw it in their fireplace and burn it if they want to. But you may want to have a contract that says you're not allowed to burn my painting. If you decide that you want to wreck it, you have to offer it back to me or sell it back to me. Otherwise, your right is to hang it in your house or in or lend it to a gallery or something like that. But you can't wreck my work or you can't deface it. So those are the type of issues that an artist is going to want to think about. So again, it's what rights is the artist going to reserve to be able to continue to use the copyright of the work that they might be selling the original of, and then do they want to preserve the rights in the work so that it can't be defaced or destroyed or ruined by someone and they're basically what's called their moral rights.
Okay, so finally, the last part of that one is specific to models.
To
So
models.
what needs to be included in a contract with models to use their image on a worldwide basis in all media?
In all medium, yeah.
Yeah, when they
So
pro-
it's,
yeah.
yeah, it's called what's called a release agreement. So if you use someone, whether the model be in print or in a photograph, or whether the model be on video and audio visual work, you need a release from that person. And when we say model, it might not necessarily be a beautiful model. It might just be people that appear in the work. So in order to commercialize it, you need to have their permission. You need to have a release, and the release generally says that the model is granting to the filmmaker, the photographer, the right to use their image and likeness perpetually, forever and ever, in connection with the work that they've created. Sometimes you get paid for it, sometimes you don't. If you guys have ever been on been to like a taping of a TV show or something like that, they might have you sign a release agreement. Or if you've ever been in someone's music video or something like that, they have you sign a release agreement that says that they can use your image in that video. And that's essentially what a model release is. It's just, if it's a commercial model, they're going to have compensation terms in there. If it's your friend that wants you to be in their music video, they're generally going to ask you to do it for free. But it's a release agreement is what you use when you're working with models or talent that's not like an actor.
All right, so this next question actually follows up that other one really nicely. So this is something that we get calls about a lot.
Okay.
Does a record company and an artist both have to sign a contract in order for it to be valid?
Essentially, yes, but there is a doctrine of law in the law that says if people perform in reliance on something and have completed tasks or done work, somebody can't just come running forward and go, "Oh, I didn't sign the agreement, so sorry, it doesn't count." Once you actually start performing on the contract, even if it's not signed, you're probably going to be bound by whatever obligation you have under the contract once performance has begun. But in general, yes, both sides are supposed to sign the contract for it to be binding. And if both sides haven't signed the contract and work hasn't started to be performed yet, it's likely that they can back out of it, or it's not going to be enforceable if someone doesn't decide to perform and didn't sign it.
All right. So with that, let me go back to the crowd to see if anyone's ready with another question. Okay, let's go back to another earlier question.
Okay.
So we get a lot of calls regarding business structure. What
Yeah.
business structure is right for me. Now, could you maybe talk briefly about the various different business structures?
Sure.
And then we could probably go into maybe a bit more specifics of a few of them.
Okay. So the most general form of a business structure is a sole proprietor. Not too many criteria that you need to meet to be a sole proprietor. You just need to start a business. And if you're operating the business under a name other than your own name, you need to get a fictitious business name or a DBA. And you would file that with the city or the county or the state, depending upon where you live. And that essentially just says, and sometimes you see it, it's printed in the newspaper, say, these people are now operating under this name. And that's just to tell the world that you yourself are operating under a name other than your own. And that's really the only thing you need to do. You probably want to start a bank account, but there you go. You're in business. You're a sole proprietor. If there's more than one person, you're a partnership. You are a partnership if you start working with someone else, whether or not you have a written agreement or any other type of agreement. Once you start working with one or more other people, it's automatically considered a general partnership. Always advisable to have an agreement between the partners so that there's a clear understanding of what everybody's duties, obligations are, and who's going to get paid and all that. But if you're working together on some type of a business, even if you don't have a written agreement, you would be considered a general partner. Next is thinking about forming a business entity, like an LLC, a limited liability company, or a corporation. There's several different ways that corporations can be taxed, but essentially a corporation is a corporation is a corporation. They need a board of directors, they need to have officers and shareholders, all the things that we think about corporations. Limited liability company is kind of a hybrid between a corporation and a partnership. It has some of the advantages of a corporation in terms of the fact that you have personal asset liability protection, and we can talk more about that if you guys want to. Also some tax advantages to being a limited liability company, but you don't have all the formalities of corporation in terms of having to have a board of directors and officers and keep meetings between the directors and the shareholders. So a little bit of a looser organization, and is oftentimes very preferable for a small group of people that are all going to work together and all put in money. If you're looking to get funding for your project from outside sources, then a corporation might be a better entity to get into because of the fact that you have shares that you can offer to the public and raise money through the offering of shares. But for a small business, using an LLC is a really good place to look. One of the things that I always tell people right off the bat, every time, right down the line, is two things. One, before forming a business entity, talk to an accountant. Whoever you're going to work with that's going to do your accounting is there's a million different ways for accountants to think about ways to maximize taxation issues and accounting issues to get the best advantage for their clients. Some accountants feel very strongly about corporations, some about LLCs, some don't care. But it's really important to talk to your accountant, because if you form an LLC because your lawyer said that that's the best way to go, and your accountant freaks out because they hate LLCs and they wanted you to be a corporation, then you kind of put yourself behind the eight ball. Most lawyers don't care what they form because they can find the way to protect you legally no matter what entity is in place. But your accountant is going to feel really strongly about the ways that they can maximize tax savings and accounting savings with one form or the other. And so it's really important there. The other thing that I always tell everybody right off the bat, super important, is talk to an insurance agent. You may not need insurance, but it's really important to talk to an insurance agent just to make sure. A lot of times people hear about an LLC and they say, oh, if I get an LLC, I've heard about this personal asset liability protection. So I form an LLC and then no one can sue me personally, so I'm totally shielded and why would I need insurance? Well, you still might need insurance. What if you're a record label and now you own the rights to a whole bunch of intellectual property, a whole bunch of sound recordings, and now you get sued? Sure, they're not going to necessarily be able to come after your house and your car, but the lawsuit might subject ownership of your sound recordings to being divested to someone else as part of that lawsuit when you have to pay for the judgment that might come down. So if you had an insurance policy, maybe the insurance policy would have covered whatever the issue was. So always important to at least look at insurance, even if you have heard of or kind of have an understanding behind the asset liability protection of an LLC. Super important to have an accountant and an insurance agent. And when I write my initial kind of outline to clients, I usually lead off with saying, do you have an insurance and an accountant? And then I end it by saying, don't forget your insurance agent and your accountant. We have a question over here.
Yes.
So the video game field develops like a lot of digital media, and since we're a small company, how will we be able to protect our assets if there's no physical media to hold and say, oh, we have this copy of this, and we don't have any money to trademark it or anything yet?
Okay, so let me repeat that. So for a smaller company that's working mainly with digital assets, like a video game company, how do you protect that when you don't have a whole lot of startup funds, right? Okay, right.
Okay, so the best way to protect what you create when it comes to intellectual property, and specifically what your company probably is experiencing, is creation of copyrights and then a trademark in your branding. So copyright rights are created the minute that you put something into a tangible form. So you don't need to register your works. You don't need to do anything special. Once you create something, there's an inherent copyright created with it that is owned by whoever creates it, unless there's a written agreement. So let's say you had that written agreement that we talked about earlier between the members and let's say an LLC. The LLC could be the owner of the copyright, okay, if there was a written agreement. But in general, the copyright vests in the author of the work, so whoever created it, and it vests the moment that the work is created. So even if you haven't put it out there in the world, even if it's just being worked on, okay, and it's not complete, there is copyright rights in the portions that you have created already. And if somebody were to try to take that and use it without your permission, you would have all of the rights of a copyright owner to enforce against someone's unauthorized or infringing use of your copyright, even without registering it. Registration of a copyright is really important because it gives you some additional statutory protections that can really be helpful when and if there's infringement against your rights. But you do not need to register your copyright in order to claim ownership. All you need to do is create something. Now, when it comes to trademarks, the trademark process can be a little bit expensive to go down, actually gaining a registration with the United States Patent and Trademark Office. But trademark rights can be established, again, through common law use, much like, copyright, where with a copyright, the minute you create something, you draw it, you write it, you record it, you sing it, whatever you do, as long as it's fixed in a tangible form, recorded or written, there's a copyright there, and it belongs to the author. With a trademark, you can establish rights through use. So your rights essentially could be diminished to some extent if there's somebody else out there using it, or somebody else that comes along and registers those rights in the same branding or the same trade name that you've selected. But if you start using it, even if someone comes along later and starts using a same or a similar name and then registers, you may still have rights to continue using your name. Now, registration is always preferred, but again, in the real world, there's all types of limitations on people's budgets and where they want to spend their resources. And so oftentimes, a trademark is not at the top of the list. It should be, but that's just me as a lawyer. But it's not always at the top of the list. And so what becomes important, though, is using it, getting the branding out there and letting the world know that you're using it and establishing a brand behind it. The United States is a first-to-use trademark system, meaning in Brazil or China, it's a first to register. So somebody could be using a trademark for 100 years, and they never register, and somebody comes along and registers, and now they can claim exclusive rights to it. In the U.S., it's a first to use. So if you can show that you were using the rights before someone who was either registered or attempting to register, you can prevail in some capacity. You may not get full rights to use it, but you are going to have some rights that as the senior user to that trademark. So it's very nuanced and technical how it works, but the general idea, if you don't have the resources to immediately obtain trademark registration, is A, do a little due diligence, go do a Google search and see if there's anybody else using the same or similar name. Do a search on the Patent and Trademark Office. You can go on there and you can search to see if anybody's registered anything under the same or a similar name. And then once you've established that it looks like you can go ahead and move forward, just use it and make it very obvious. And again, the easiest way to do that is to establish strong presence on the internet, so that when people search for whatever the term is that you're going to be using, you come up first in all the search engines, and you create that strong brand. And it ties into what we were talking about before with the recipe, in that the stronger your brand, the more likely you're going to be the market leader. Especially with something like a game, games inherently are there are ideas that are kind of inherent throughout lots of different games. And so inevitably, when people go to develop, whether it be a music or a game or anything creative, there could be an opportunity that they run into a situation where somebody else is coming up with something that's similar. They didn't do anything illegal. They're not stealing your idea. They just came up with it independently, and it happens to be somewhat similar. And so the best way to protect yourself is to be the best at what you're doing.
Okay.
Yeah.
Did that answer your question? All right, so there's two other questions. We got one over here and then one over here.
Okay.
So, okay, what was the question over here?
Okay, so my question was, pretty much, how much do you think is, like, copywriting, for instance, like, a poem?
So what's the value in copyrighting a
Yeah.
poem? Should you copyright a poem? You mean
Or, yeah.
you mean register the copyright of a
Register
poem?
the copyright, yes.
Yeah.
Okay, all right.
Yes, you should probably register your works.
One moment, we're having some
Right.
technical difficulties. I'm sure everything
no
will be
worries.
fine. Everything will be fine in just a minute. We're singing, that's all.
Yeah.
Okay.
I know we're boring up here, I'm sorry. Talking about the law and copyrights. I get all geeked out
Makes-
over this stuff. I get all excited, and then everybody's like, man, you get all excited about some stuff that like is like really weird, and I'm like, yeah, I guess so.
It happens.
It happens.
I don't know.
No, but to address your, okay, so, like I was saying to these gentlemen over here, that, when you've created your poem and written it, you have a copyright in it. You have the exclusive right to make copies, distribute, exploit, display, and make derivatives of your poem. That belongs to you. You don't need to do anything special. That's yours. Registering, what that gives you some additional statutory protections. It's kind of important in today's world with the internet because people will steal your stuff and they may not even know they're stealing it. Now, what's nice is if somebody does take what you've created and use it on their Facebook page or put it on YouTube or whatever it is, there's a mechanism in place where you don't need to prove anything with a document. You just need to go and affirm, write an affidavit to Facebook, and then there's an online form you can do that says, I attest that this belongs to me, not to the person that posted it, please take it down. And then there's a process whereby Facebook will take it down and then notify the person who originally posted it saying, somebody has made a copyright claim, we've taken it down. If you feel that you actually are the owner, you can counter their claim. And so there's a process that you can go through, but you don't need to show any documents or anything. You just need basically swear under penalty of perjury that what you're saying is true and that it's yours. Now, if somebody's using your work and trying to gain commercial advantage over it, this happens a lot with photographers, where a photographer will have pictures on their website and somebody will come and take those pictures and use them on their commercial website and either make money off of or use them in a way that the photographer's ability to make money off of their own work is diminished. So in that case, it is important to have a registered copyright because of the additional statutory protections. Specifically, if you have a registered copyright, well, one, you can always sue in federal court, which is generally going to be a little bit faster and have people in that court system that understand intellectual property rights maybe a little bit better than a state court would, especially the judges. No offense to any judges, but federal court judges deal with intellectual property more often than state court judges do. So, so that's just kind of the way that is there. But the second thing is that you have statutory damages, meaning when you have a lawsuit in the United States, you generally are suing someone for damages, meaning they've caused you some wrong, and so you're asking the court to compensate you for the wrong that was caused to you. That's the same principle with intellectual property. If someone stole your poem and used it on their website. So let's say it's very easy for you to say, that's my poem, here's the date I wrote, I've got everything proving that that's my poem, and they don't have a permission to use it, and they posted it on their website. So you prove 100% without a doubt that they infringed on your copyright rights. What are the damages?
What would be the damages?
What are the damages?
The damages are what? Like that it's not original to them?
Well, what are the damages that you're seeking? So let's say you prove that I infringed on your copyright, and you go to the court and you say, Mark infringed on my copyright, I can prove it. What do you want?
Oh, probably just for them to take it down.
Right?
But I mean, like you said, if it
What,
would be.
how do you come up with what the compensation is? It's difficult, right?
I know,
You're
but
going,
how do you know?
how do you know? How do you know what the value is of what I took from you when I took your picture and posted it online, right? That can be very difficult to prove. So in the law, in the Copyright Act, they say if you have a registered copyright, you don't have to worry about proving damages. You can go to court, prove that there was infringement, and then let the court decide what the damages are. And the court has a discretion based on whether or not they feel that what I did was willful. They can award you an amount somewhere between $20,000 and $150,000 for each occurrence that I infringed on your rights. So you don't have to worry about the expense or the hassle of trying to figure out what the damages are. You can rely on statutory damages. So what this does is it puts you in a very advantageous position. I may have just taken one of your pictures, put it on my website. You have it registered. You know that it caused you grief. You send me a letter saying, hey, you used that without my permission. I have a registered copyright. If I sue you, I can get between $20,000 and $150,000, but I would be willing to settle for a lower amount right now instead of going through the hassle of suing you. And so it puts a lot of leverage in your pocket as the copyright creator. That's why you want to register. So if you think somebody's going to use your work,
Even
or
so what about pictures? How does that work?
same thing.
Same thing?
Yeah, and when it comes to registering works, it's not super expensive and it's not super complicated. Most people can do it themselves with the online. And they also let you register in bulk. So if you have photographs, you can register a whole bunch of photographs in one registration. So you don't pay a fee for each photograph, you pay a fee for all your photographs or a collection of your photographs, yeah. So registration is fairly economical. It makes a lot of sense. And in most cases, you can figure out how to do it online. If not, then call CLA or call a lawyer that you know, and they can walk you through it. And it's not super difficult, but it is important to protect your rights and give you those statutory damages provision. You also, if you prevail, would get your attorney's fees paid, which is not the norm. Normally, everybody's responsible for their own win, lose, or draw. But if you have a registered copyright and you sue and you prevail, then the other side has to pay your attorney's fees as well. So it really puts a lot of leverage having that registered copyright in the hands of the copyright holder in the event that there is infringement. So it's a good thing to do if you feel like you're going to be infringed.
So before we get to the next question, I want to lead you all to a website where you can read up on all this. If you go to the copyright website, which is just www.copyright.gov, they've got a really good FAQ question that answers a bunch of these questions, and they have what are called circulars. And so these circulars are basically written lessons on copyright and how to use it and what you need to do in order to get it registered. So I encourage you all to maybe take a look at that.
Yeah, and they're actually pretty good. For the government, they actually did a nice job putting that together and making it fairly easy to interpret what they're actually talking about. Yeah, I like the circulars. Much easier to understand than the IRS circulars.
Oh, yeah. All right. Now we had another question over here.
Yes.
So going back to one of the earlier questions, what language is needed to own all the underlying rights when commissioning an artist to do graphic design or paint work?
Okay, so that question was, when you're commissioning an artist to do any sort of graphic work, doing any sort of graphic work, what language do I need to use in the written agreement to ensure that me, the guy who's contracting him, gets the rights? All right.
So you want what's called a work for hire agreement, or work made for hire. Built into the Copyright Act is a provision that says that the author of the work owns the work out when they create it, unless it's a work made for hire. And then it gives some instances where the work made for hire would be applicable. One of them is a specially commissioned work. Okay, so a piece of artwork that's specially commissioned is likely going to fall under one of the categories that is available for work made for hire. So you need to make sure that specific language calling the work as a work made for and explaining that all the rights in the work vest in the contracting party, in the person who's paying for the work, then that's what you need. And essentially there is some specific language calling out that work made for hire that you want to put in there. And I don't really want to say exactly what that language is here in case somebody misunderstands or it gets miscommunicated and they rely on it to their detriment. So I'm not going to say exactly what it is, but it's fairly simple wording that you would want. And if it's something you want to talk about later, I'm happy to tell you what it is off camera, but I don't want to say it on camera and then have somebody, mess it up and then get upset and think that they got some bad advice. But that's what you want, essentially, is work made for hire agreement. It basically says that you are hiring them to do a specially commissioned work for you, and therefore you own it the moment that it's created.
Did that answer your question? All right. Okay. Anybody else right now? Yes, we got one more.
Excuse me. I have a question about umbrella branding.
Okay.
You have like one major house company.
Yep.
And you have a bunch of other different products.
Yep.
And naming these different products, should it be the same as the house name, or would you like put like a little logo next to it? Like for example, Coca-Cola.
Right.
How they have different products that they
Yep.
own. I have a question about would I have to get, trademarks and like papers written for rights for each product, or would it just be fine if I said the whole house
Mhm.
brand name?
So,
Hang on a second.
yeah.
All right,
Sorry.
so the question was, when you have an umbrella corporation with many different products underneath it, do you need to have a trademark for each one of those products, or should you just get one trademark for the whole umbrella, right?
Yeah.
More or less, okay.
Yeah, so essentially, a trademark is a word or a logo or a slogan, it could even be a sound, like, remember the Yahoo Yodel? That identifies the origin of goods and services. So it's not the name of the products themselves, but it's the company that you think of when someone mentions those products, or when somebody addresses those products, you think of that company. So in thinking about it in that way, you want to brand or trademark all of the different brands within your umbrella, but not necessarily the name of every product. They may not every name is going to be subject to trademark protection, but all of the branding that you do is. So to the extent that you have like 6 different brands under your umbrella company, yes, you would want to get a trademark in the 6 brands. But those 6 brands may have products that don't have specific branding behind them, or just generic type products, in which case those wouldn't necessarily have trademark protection. Because again, trademark is is identifying the origin of goods and services. So for instance, if you see the big giant M in gold, you automatically think McDonald's. And they could put the M on anything, and you'd go, oh, look, McDonald's is now selling that because it's such a well-known brand and a well-known trademark. That's what a trademark is essentially supposed to do. When a consumer sees that mark, they immediately have a commercial impression that's formed in that brand because they're familiar with it, and they think of whatever the product is as being associated with that brand, good, bad, or indifferent. So if you see the giant, golden M on, packaging or on a restaurant, you're automatically, whether you have a good or bad impression of McDonald's, that's what comes to mind. When you see the Nike swoosh, if you think that Nike makes good shoes, you immediately, when you see that swoosh on a product, are going to have a favorable or disfavorable impression of that. That's essentially what a trademark is there to do. So as you move through, sometimes what started out maybe as the name of a product, which wouldn't necessarily carry trademark protection, ends up becoming something that obtains trademark protection. So that can happen too, because all of a sudden what was just the name of a product, all of a sudden becomes branding around that product. And you're selling all kinds of things that are branded under that product's name. And then you would then definitely want to obtain a trademark in that. So I know it's kind of a little bit nebulous, and it's tough to make a clear explanation without knowing like specifics on things. But in general, like if you think conceptually about a trademark, you should be thinking conceptually about the branding behind the product and the commercial and what you want the consumer to think of as your brand when they see that logo or hear that name.
So I guess I was asking more like, where should I place more of my attention, because it's not the timing. So
Right.
putting more at the umbrella company, so it's like the house, like put more attention into that trademark.
Yeah.
That logo. And then when people see that, they know that, okay, I recognize that.
Yeah.
And not so much attention on like making each trademark,
Well,
each product.
It depends. There are some huge companies out there that make all kinds of products that we all know and are heavily branded, but you have no idea who the parent company is.
Right, and that's what I know,
Yeah.
that's what I was asking the question, because.
So your parent company may not be the one that you want branded. Maybe you've got 3 divisions that are really making products, and those are the three things that you want to actually focus your branding attention on.
What I've been doing is focusing my attention on the parent and all the children.
Yeah, and sometimes you want to. It just depends on your business. There's no one way to do it. What's important is understanding that anywhere along your chain that you have created something that you think resonates with the public, or that you want to resonate with the public as being a brand, that's where you want to think about, establishing trademark rights. Yeah.
Thank you.
Sure.
All right, okay, so we had 3 questions, here, and then here.
Okay.
So let's take you first.
So what kind of registration should I do when it comes to curriculums or like paperworks and worksheets?
Okay, so that question was, what sort of registration do you need for curriculums and worksheets, like for a school or something?
Yes.
Okay, all right.
Yeah, so that's copyright. Yeah, and so essentially, depending upon what it is and what the information is. Now, statistical information, factual information, in and of itself is probably not going to be subject to copyright protection. The way that you have arranged it might be. So if you wrote a book that was filled with, what's a really good example? I keep score at the baseball game, right? So I have a scorebook that I do the scoring in. The concept of a scorebook and the fact that it has a baseball diamond on it, and it references the numbered positions on a baseball field, and it uses words like pitcher and outs and strikes. None of that is subject to copyright protection. But the way that the author actually arranged this book for me to fill out, that portion of it is copyright protectable. So the way that he drew the chart out for it is copyright protected, but the specifics of it inside of it aren't, because those are kind of general things that are associated with baseball and not something that someone can lay copyright claim to. So when thinking about it from a perspective like teaching, to the extent that the information that's in your curriculum is information that is factual or not something that you came up with on your own, that portion of it would not be protected. But the way that you put it together, the order that you put the book together, the way that you structured the book, if you included any design elements in the book, all that would be copyright protectable. And again, that right of copyright would vest in you as the author the minute you created it, even if you didn't register it. So you could choose to register it if you felt you wanted to, if you felt somebody was going to take it and use it without your permission, or you could just rely on your common law copyright rights, which you could still enforce against anybody that tried to use it without your permission, but you didn't necessarily get registration on it. Yeah.
Kind of bounce off of that.
Yeah?
So what if I'm like selling it to schools?
Yeah.
Okay, so if you're selling the book to schools, right?
Yes.
Okay.
Yeah.
Selling worksheets.
Well, if you're selling it, then you should definitely explore the opportunity of registering it. If for no other reason than once you put it out there in the public, it's inevitable that somebody would possibly use it without your permission. They might have a fair use argument to using it because it's in the educational space, which is a whole different discussion. But in general, once you start marketing and you take something to market, or you're going to be using it and selling it, and so it's not just pictures that you posted on the internet or a book of poems that you wrote for yourself that you haven't really published or anything. Once you actually take something to market, you definitely want to have a registration in it. If you are working with a publisher or somebody along those lines, the obligation to have it registered might fall on their shoulders by virtue of the agreement that you have with them. So if you are going to work with a publisher, you might shift the burden to them to actually make to file the copyright registration. You'll just want to make sure that they do it in your name as the author, so that you preserve your rights. But yes, if you are actually selling it, you definitely want to explore registering your rights with the Copyright Office. And again, copyright registration is fairly economical, and it's also not super complicated. It's not complicated in the way that trademarks are, and certainly not complicated in the way that patents are.
Not at-
Yeah.
Did that answer?
Confused like which is which.
I was just gonna say, what's the difference between
Yeah,
patent
like
and
trademark.
copyright?
Okay.
and trademark?
Okay. So
Yeah, let's
yeah.
get this down right now.
Right,
Let's do
right.
this.
Delving more into that?
Yeah.
What's the difference between-
Absolutely. So the question was, what's the difference between copyrights, trademarks, and patents? Really good question. So a copyright is going to protect creative things that are fixed into a tangible form. So not ideas, but anything that's creative that you come up with, that you write, or that you record, or that you film, or that you take a picture of. Those type of things is generally going to be subject to copyright protection. Trademarks, again, protect your branding. So a trademark, again, is a word or a logo or a slogan or a sound that identifies the origin of goods and services. So the Nike swoosh or McDonald's, that's a trademark. And then patents are going to protect functional items. So to the extent that something has a function to it, and that function is new, novel, and non-obvious, that's where patents are going to come into play. So inventions, essentially, is where we think about patents. And again, to qualify as a patent, it has to be new, novel, and non-obvious, so you can't get a patent in something that everybody already knows how to use or do. So patents cover functional things, copyrights cover form or creative things, and then trademarks protect branding. So hopefully that kind of helps out. So your written works are creative. That is going to be copyright protection. Yeah.
Okay, you can talk to us more about that after the stream, and we can go into it a little bit more.
Sure.
Okay, I'm gonna go here, and then I'm gonna go here. Okay, go ahead.
Okay, like for example, okay, I'm a dancer or whatever,
Mm-hmm.
and it was this artist, and I like made a video dancing to her song or whatever.
Okay.
And like when her music video came out, she kind of like took my concept and like some of my moves and stuff. So how do I kind of go about that?
Okay, so let me bring that up. Okay, so we've got here a dancer, and he filmed. You were filming yourself? Okay, you filmed yourself dancing to an artist's song, and then when that artist came out with a music video to that song, there were some similarities in her video to what you did, right? Okay, so what can he do in this case?
Yeah, so it's kind of tricky, and not having like seen exactly what we're talking about, I'm going to kind of just give you some generalities, okay? What's that?
Show us afterwards.
Yeah,
We'll
show us
take a look
afterwards.
at it.
We'll take
Yeah.
it. Yeah. In general, one of the things that's subject to copyright protection is choreography. So choreography is copyright protectable. And again, you don't need to do anything to preserve your rights. You just need to create the choreography. One of the tricks with choreography, though, is that individual moves in and of themselves are difficult to lay claim to because most dance moves are kind of general. So when we talk about choreography, we generally are talking about like a piece of work where someone's copying the whole piece. The interesting thing about copyright law in general is that for different areas of the arts, copyright law is going to be interpreted a little differently. For like graphic arts, it's really going to be, did somebody take your artwork and use it? Did somebody take your photograph and literally use your photograph in something? In music, it's a little more nebulous, right? We talk about like the Blurred Lines case of a few years ago of copyright infringement, where it's clearly not the exact same song, but the jury and said that they were essentially it was a copy, even though it doesn't sound exactly the same. That same principle wouldn't hold for a photograph. You would literally have to use somebody else's photograph in order for it to be copyright infringement there. And then again, when we're talking about like choreography, it's more the amount of the choreography that someone took, as opposed to taking one move that many people could say that they came up with. So it's really more nebulous in copyright law than it is maybe in some other areas of the law in interpreting, especially in the arts, where there's infringement or not, right? So I would think in your situation, there might be other issues at play that might be outside of the context of copyright. Perhaps unfair competition laws might be something that might be there, where somebody uses a trade secret of yours without your permission, and they only learned of this because of their exposure to you, and that's what you get paid to do. So maybe there's an unfair competition claim in there. So there may be other areas of the law that are germane to what happened there that are outside of just copyright infringement.
Yeah, so talk to us more about that later afterwards. Okay. Let's go over here, and after that, we do have an online question that we'll get to right after yours. Okay, go ahead.
So in terms of our company, we definitely want to trademark our logo and whatnot, but will we also be trademarking titles under our company?
Okay, so that question was, in addition to your company's logo, would you have to trademark every single title that you put out? Okay.
So in general, titles to works are not subject to copyright protection. Now, oftentimes a title will take on a trademark life of its own once it's out there, because branding springs up around it. So this happens all the time in the video game world. It happens sometimes in the movie world too. Star Wars originally was just the title of a movie, but now there's a huge brand around it. It's clearly a trademark, but originally it was just the name of a movie. So with your game, to the extent that you're going to do branding around the game, like you're going to offer, toys and other types of offshoot merchandise, or you're going to set up, a website where people can come and get additional information about the game and learn about other things that are going on, you can create a brand around your game. So yes, you can think about a trademark for your games if you are truly going to do branding around the game, which quite often is going to be the case. So yes, and then you're definitely going to want to have a trademark for your company as well. You can trademark logos, and you can trademark the word mark itself, depending upon what's going to be best for your particular business. And so it sounds like with what you guys are doing, it would be really worth your while to sit down with someone and talk through all the different issues and get some counsel as you think about moving forward. I think that not knowing what your brands are or what the names and the logos you're using are is probably a really good idea to start by making sure that you conduct a search to make sure there's nobody out there using something that's similar, so that you don't run afoul. You don't start spending a lot of money on your marketing and your branding campaign only to find out that somebody else has the rights to it already and then comes after you and says stop, and now you're stuck between either fighting them or starting over and throwing all the time and effort that you put into it away and starting over on rebranding. So it sounds from the questions that you guys have asked that you're at the point now where it might make sense to talk to somebody that has some expertise in this area of law and get some counsel so that you guys are making the right decision because you're going to be spending some money on these type of things, and you want to make sure that that you're doing it right so you don't waste your money.
Call the lawyer referral service. All right. So now we've got our online question, so this kind of dovetails nicely with what we're talking about. They want to know, can you get a copyright and a trademark for the same thing?
You can.
You can?
You can. I once knew a case where one thing had a copyright, a trademark, and a right of publicity, which is a state right that is tangential to intellectual property, all in one thing. And we all know it, and we've all heard it a million times, and it is Michael Buffer saying, "Let's get ready to rumble." When Michael Buffer says, "Let's get ready to rumble," that is a trademark of his brand. When he says it, it's his copyright because it's him speaking it, on the recording that he does, whenever you watch it on him on TV, that's his copyright within there, which he licenses the rights to use to Showtime or HBO or whoever he's worth. And then it's his right of publicity too, because it's actually his voice. And right of publicity protects the commercial appropriation of someone's name, image, voice, and likeness. So you can't use somebody's name, image, voice, or likeness for commercial purposes without their permission. So let's get ready to rumble. When Michael Buffer says that, it's literally a trademark, it's a copyright, and it's a right of publicity all in that one sentence that he says. So yes, you can have all of it in one place, and that's the example that I like to point out there. I don't know. I guess, so when it comes to patent, oftentimes what people will say, and of course there's going to be no necessarily right of publicity here, but if you invent a box and you put your logo on the box, and then you have a special hinge that helps make the box close nice and slow so it doesn't slam shut, and then you have ornate decorations on the box. Your logo on the box is a trademark. The hinge that was created that makes the box close nice and slow is a patent on the hinge, and then the ornate decorations that are on the box would be subject to copyright protection. So that would be another place where there would be all of them, but it's not as cool as the Michael Buffer example. So.
I like that one. We can't do that here for the obvious
right?
reasons. Okay.
Yeah.
That would be bad. All right, so we've been talking a lot about protection, and so this next question that somebody wrote in, just a second. They ask that, so when they want to register something that they've written, let's say it's a book or maybe it's a song, they asked, well, if I registered it with some other body, like let's say the Writers Guild or BMI or ASCAP, is that just as good as registering it with the Copyright Office? Does that get me the same protection?
No, it doesn't. The only way you can get those statutory protections we talked about, which is the statutory damages, so not having to prove your damages in a copyright infringement, but being able to rely on statutory damages, the ability to sue in federal court, the ability to get your attorney's fee paid for, and actually having a record that somebody would have to get through before they could actually try to claim that something is theirs because you have the registration for it already. The only way you can obtain that is by registering with the Library of Congress, the Copyright Office. If you are a screenplay writer and you sign up with the Writers Guild, that's great. If you're a songwriter and you have a performing rights organization, ASCAP, BMI, CSAC, that's great, but it's not a substitute for actually registering your copyright. And so you want to register with all those things. And if you're a songwriter and you've created music and you have a sound recording, you also probably want to register with the Sound Exchange. And if you're a writer, you might want to sign up with any number of different organizations and unions that cover whatever it is you're writing and whatever genre or style that you're writing for. So whether or not you're a member of a union or a guild or a performing rights organization or anything else has no bearing on registration of your copyright. You should do all of those things independent depending upon what area of the arts you are working in.
Register your copyrights. All right, let's get this question over here.
Yeah, so my question is mostly about the LLCs
Mhm.
and the sole proprietorship. So when do you think is the best time to register as an LLC? Like the middle of your business when you're done getting customers and stuff, or should I do it like right in the beginning?
Okay, that question was, when it comes to a sole proprietorship or an LLC, when's a good time to actually act upon it, form the business?
So there's no 100% black or white answer to that. I generally will tell people that the minute you take a product to market and you're interfacing with customers or the general public, you want to have your business entity in place. There's some timing things on when you might want to register, like during the year, because of franchise taxes that you have to pay to California and fees. And so sometimes if people come to me at the end of the year, I say, can we wait till January to file so that you can save on some taxation issues? But in general, there's no one answer. It's really going to be specific to your particular business as to when you want to think about registering. But in general, anytime my advice to most people is, as long as the resources are there to implement starting a business entity, to do that as soon as possible, and definitely before you actually start interfacing with the general public.
Okay, did that answer your question? All right, yes?
So I am a songwriter and also a performer and also a recording artist. So I've done copyright before and I've seen that there's these different categories that they want you to choose that you did. And it's easy when there's a project that I'm the only one that did something on it, but what happens when you have the producer that made the beat and then the person singing with royalties? Like, I don't even know if this is a question that you can answer, but
Sure.
It's been hard for me to think about that percentage. So when I go to write this work for hire agreement, and I say, okay, after I paid for this upfront, you're then allocated to this amount of percentage of royalties later. Like, how does that calculation happen, or is there any resources where I could possibly calculate it on?
Okay, that's a good question. We got one of those asked earlier along those same lines. So we have a singer-songwriter performer over here, and so she says, when I'm writing a song out, it's easy when it's just me. But once other people start getting involved, how do you calculate those royalties? Who gets what, and how do you write that up? Did that answer? Was that your question? Okay,
Yeah.
all right.
So you're in a unique world of working in music.
Just a second.
Up.
So here we have a singer-songwriter
Singer-songwriter right
performer
there, yeah, for
who's,
sure.
doing her thing. Future star.
For sure.
All right, okay, let's.
So you're in a unique world of working in music where you've got two distinct copyrights that you have to worry about with any piece of music that you put out there. You've got the copyright in the actual lyrics and melody of the song, so the composition copyright, and you've got a copyright in the sound recording, the version of that composition that has been recorded by you or your band. And so you always have to be thinking about who owns the rights on both sides, because they could be very different people. It could be a record label that owns all the rights to the sound recording and is paying you royalties, and then you have an agreement with other people that worked in the studio to help you record it, where you're going to take the royalties that you got and divide it and give some of it to them. So it can get very complicated just on one side, and then you got to have the whole other side of where you're dealing with the composition copyright. Who actually wrote the song? Who actually wrote the lyrics and the melody? Sometimes it's tough to tell depending on the genre that you're in. Generally, like with hip hop, which I think you were mentioning, you've got a producer that comes in and wrote the beat. Generally, that person is probably going to be considered the person who wrote the melody of the song. And then you have somebody who comes in and has the lyrics that they brought, and they're generally going to be considered the person that wrote the lyrics. Then you say, okay, well, what percentage economically of the copyright and the composition does the person who wrote the melody have as opposed to the person who wrote the lyrics? Is it equal? Is it unequal? And there's really no right answer. It really comes down to the 2, 3, 4, however many songwriters that there are, and then sitting down and saying, okay, what's going to be fair? What do we think is the right way to divide up the economic assets? When it comes to registering your rights with the Copyright Office, they don't care what your economic interest is. They only care who are the songwriters. When you list the songwriters on the copyright registration, it doesn't have a spot that says this person has this percentage. It just says who are they, and you just list who the songwriters are on any particular song that you register. But you're right, you have to have an agreement, and it could be that one person's going to own everything. It could be that multiple parties are going to all own their share individually. There's so many different ways to set up agreements in the music industry, especially now where you don't necessarily have huge gatekeepers in a music publisher and a record label that are dictating everything, where a lot of music is now recorded independently. So there's so many different ways to structure the particular deals. In general, you want to structure the deal that's going to make it easy to get the work out there and easy to get it licensed so that everybody can start making money from it. So oftentimes people worry a lot about, oh, I got to protect my right in this, I want this, but sometimes it's easier to protect your economic interest and let one person be in charge of the rights, so that it's easy for that one person to go out and exploit the rights. In other cases, maybe not. In other cases, maybe everybody that participates wants to hold on to their rights and all be signatories. There's just no one way to do it now, and so it really comes down to the specifics of the particular situation, the specifics of the people involved, and going from there. To address the issue about the actual registration form, you can register your sound recording and your composition copyright on one form, and you can really do that very easily if it's you that wrote all the songs and own all the recordings. It's very easy to do that. But if you have multiple songwriters involved, or you have multiple people that might be laying claim to ownership of the sound recording, then it gets more complicated, and you might have to do multiple registrations and not rely on the one registration for the full album or for all the songs. So even there, it can get complicated. So I'm sorry we don't have a black and white answer for you, but there are answers. That's kind of the gist of this, is that there are answers, but it's going to be specific to your situation. And so you're going to want to sit down and both talk to the other people involved, and then maybe talk to somebody that understands, a lawyer or something that understands these issues and can put together the correct documents that's going to work for everyone. And again, the end game is making it easy to exploit the work and generate income. Yeah.
So if you need help structuring that, call California Lawyers for the Arts, because we do have attorneys who work in that area. Okay, so we're coming up on, I think we could have 9 minutes now, so my producer just gave me the signal. So we've got 3 questions, so I'm going to do the online one first, so you can make sure that one gets answered before 8.
All right.
Then I'm going to come over here, then I'm going to come over here, because we're still going to be here after 8 o'clock. Okay. All right, so the online question is, how long does it take to form a business in California? And what about all those ads for business formation in Nevada or Delaware? Is it better to form a corporation outside of California? Mark?
Okay, so here's the kind of the short on forming a corporation. In California, how long does it take? Depends on the time of year that you file. Because of the fact that California charges you an $800 franchise fee the first year, the year that you register, a lot of people don't want to register in December because they'll have to pay an $800 fee for November and December, and then have to pay again in the middle of March for the next year. So you basically get like $1,600 and you haven't even had your business open for 5 months. So a lot of people wait until January 2nd. We can't file on the 1st because it's a holiday, but January 2nd to file for your corporation or your LLC in California, because that way you get like a full year for your $800 essentially. So because of that, when you file in January, expect to wait 3 to 4 weeks before you actually get your paperwork back from the state. If we file today here in April, it's a week and a half that they turn around and send you your paperwork back. So it depends on the time of year. If you go like when I file for a business entity and set one up, I use a document submission service in Sacramento that will hand walk the documents down. And so that way they'll know that the document is going to be processed, that there aren't any technical difficulties with the document itself. There wasn't an I that wasn't dotted or a T that wasn't crossed. And so you can have a reasonable expectation that that day is going to be the day that your business entity was formed. And it's just then waiting for the bureaucracy to run its course and get the document back to you. You also have the option of mailing it in which case you're not sure exactly what day they got it and what day they processed it, but it's going to be a little bit less expensive to just mail it in. But generally in California, anywhere between a week and a half, 2 weeks to a month, depending upon what time of year you file for your corporation, is when you'll know that it's been registered, and you'll have the document back, and that document is called the Articles of Incorporation or the Articles of Organization, depending on the business entity, and it is like the birth certificate for the business, and it is essential that you have that because that's what you're going to need to show in order to form a bank account. So it's a very important document. Second part of the question.
Second part of the question was, should I form the business in Nevada or Delaware? What's the benefit of doing it in California?
Okay, so essentially here's where we come down to forming it outside of the state. And oftentimes if you go to like an online document submission company, they will try to persuade you to form in Delaware because it's in their advantage, because essentially if you form in Delaware, you will have to hire them to be your agent in Delaware, and so you're going to have to pay them money each year to serve as your agent, because if you file in Delaware, you don't actually have to be there. You don't have to have a physical presence there. You can hire someone to be your physical presence there. And so you pay some money to them, around $150 to $200, depending on who you use, to be your proxy in Delaware and give you an address. And then you can set up your LLC or corporation in Delaware. The problem is if you're doing business in California, then California says you're doing business here, so if you're a Delaware corporation, you're a foreign entity here, so you then have to sign up as a foreign entity in California, which is the exact same thing essentially as signing up as a business entity. So now you're paying all your fees in Delaware, and you're now paying all the California fees as well. So now you're paying 2 sets of fees every year to operate here. So the only time setting up in another state is advantageous is when you're actually going to be operating in that state and not in California. Otherwise, California is going to find out that you're there, and they're going to say you need to be registered here as a foreign entity. Now you're paying double fees. Now, Nevada is an interesting option if you live in Nevada, but Nevada, unlike Delaware, does not allow you to form a corporation or an LLC in that state unless you are actually physically located there. Nevada actually knows all of the private mailboxes and all of the places that people will try to use for an address, and if you use one of those, within a month or so after you form, you'll get a letter saying, we went by your office and it's just a private mailbox. Prove that you're actually in Nevada, otherwise we're going to cancel your business. Why do people want to register in Nevada? The costs are a lot lower. Same thing with Delaware. Delaware's fee for an LLC each year is $300 as opposed to $800 in California. And even if you tack on the fact that you've got to have the agent fee of $200, that's still $500 compared to $800. But when you're paying $500, then California comes and says, and you got to pay $800 to us too. All of a sudden you're going, well, that $500 doesn't look so good anymore because now it's $1,300. So if you're doing business in California, just bite the bullet, register your business entity here in California. if there's some other prevailing reason. A lot of big corporations are in Delaware because Delaware has a court system that's streamlined to handle corporation and corporate law cases, and the judges only do corporation and corporate law cases, and so they have specialty in that, skills in that. Whereas in California, you just get whatever judge. The judge yesterday could have been deciding a dispute between neighbors on a fence, and today he's presiding over a corporation case. If so, you wouldn't have that in Delaware. And so sometimes people have a big corporation that think they're going to get sued a lot, will form in Delaware for that reason. That's why big corporations are all generally you see that they are formed in Delaware. But for a small corporation, just file in California, bite the bullet, pay your $800 for the franchise tax, and just operate above board.
Yeah. Okay, so we are coming up on 2 minutes until 8 o'clock, so we're not going to get these last 2 minutes, these last two questions on the stream, but stick around. Okay, so thank you all so much for coming.
Yeah,
thank you
you.
for braving the weather out there. So let's have a big round of applause for Mark, please.
Thank you. I appreciate it. Thank you.
Okay, and for everybody who's at home and watching us, please leave a like and subscribe to our YouTube page so we can do more of these Q&A sessions. There's a new fan back there. Right. So we can do more of these Q&A sessions, and so we can launch a full-service live streaming channel soon. Thank you and good night.
Thank you.
Thank you very much for watching. If you would like to see more videos by California Lawyers for the Arts, please like and subscribe to CLA's YouTube channel so we can provide full-service live streaming programs soon. Our channel will be producing videos that cover all kinds of artistic, entertainment, and intellectual property legal issues. You can also find our videos on Facebook and livestream.com.